is My name is Kendra Hall, and I am a partner at Procopio Corey. I've been practicing litigation for 32 years and started out doing trial work at a litigation boutique for about 10 years until I really started to focus on doing appellate work exclusively. I became certified as an appellate specialist in 2003, and since then have been lead counsel in hundreds of appellate proceedings, and I probably argued over 100 cases in the California state in federal court, including the California Supreme Court. So today we're going to talk about building a winning appellate strategy. And the agenda, let's see. When and how to start preparing for an appeal, including choosing the right appellate counsel. Preserving the record and avoiding waiver. Waiver is a huge issue for appeals. Appeal timelines and the standards of review in identifying what issues will give you the best chance of success on an appeal. So a lot of people, not this audience, but a lot of people think a jury verdict or a final determination from the trial court is the end of the case. And really, there's a second half, and it's the critical second half because that's when the judgment or order becomes final. So appeals are very essential tools that drive outcomes in litigation. And thinking about appeals, what issues might be appealable, preserves options and leverage. And you all play an important role in recognizing those issues and preparing for an appeal. So evaluating the need for appellate expertise. So there's about 195,000 active attorneys in California. Of that, there's about 300 certified specialists in appeals, and they handle civil and criminal appeals, probably a 50-50 split among those 300. So it's less than 1% of lawyers in California. It's a pretty niche practice. And the requirements to become a certified specialist include taking a one-day sort of bar exam, focus exclusively on appeals. You have to provide a really detailed list that spans a 5-year period of all the appellate work that you've done, whether it's briefs or petitions for rehearing or petitions for writ of certiorari in the California state and federal court. There's a specialized MCLE component. And one of the more difficult requirements is recommendations from attorneys, typically that you've opposed, and also appellate justices. So it's a pretty a tough certification to achieve. And then you have to be recertified every 5 years, including getting those justices to confirm that you are someone who should be considered an expert. Let's see. So let me just say this. There are many trial lawyers that are excellent appellate lawyers as well. But the skill set is very different. And so sometimes it is necessary to bring in an appellate lawyer. And appellate lawyers can handle appeals soup to nuts. They can be collaborative, editing a brief that's been drafted by a trial counsel, and sort of issue spotting and collaborating in that manner. And also, sometimes I'm asked, particularly by appellate lawyers in other states, to serve as local counsel, just to help navigate all the different rules, because each court of appeal is quite different in terms of procedure and what they expect in their filings. And so the benefits also include, when an appellate lawyer looks at a case, they haven't been in the trenches of trial, which can become, pretty emotional, and people can become pretty set in their viewpoints about what issues should prevail. And so it avoids tunnel vision. You get that fresh perspective, perhaps a little bit more objectivity and neutrality. And it's just hopefully a valuable opinion to analyze, does it make sense to appeal something? Or for example, on the other hand, should we try and settle a case that's being appealed? How is this going to work out for us? So I want to take a minute just about, and I hope this isn't too basic for you all, but why are appellate and trial work so different? Many times I hear, well, my trial lawyer prepared this fabulous motion for summary judgment. All the facts and authority is there. Why can't you just repackage that into a brief? And it really is a misconception that that would be successful on appeal. And even if I'm the party or person that's been asked to draft a dispositive motion like that, because everybody knows a case is going to go up on appeal, I end up doing a lot of additional research, redrafting, reframing the narrative for the appellate court. It's quite a different voice than the pleadings you read in the trial court. So, trial courts are fact deciders, and the trial judges are given a lot of deference by appellate courts in terms of those factual determinations, or if a jury has rendered a verdict. There's tremendous deference given by an appellate court to those factual determinations. Appellate courts are looking for legal error. Even if an appellate justice reads a record and says, I cannot believe people believe this witness, like they were impeached left and right, they have to defer to that. So it's not the role of the appellate court to second guess fact finding. And so for that reason, an appeal is never a second bite at the apple on factual type issues. Importantly, trial courts are just considering the facts in the case before it, and they're applying the law to those facts. And the law that they're applying is based on the district in which they're sitting. So a San Diego Superior Court judge is required, if there's authority out of the Fourth District Division I here addressing an issue, to apply that. Even if Riverside, Division II has decided that issue differently, our Superior Court here in San Diego doesn't have the flexibility to decide which one is right. Appellate courts are not so limited. Unless there's Supreme Court authority, binding authority on an issue, appellate courts, including panels within the same appellate court, can decide legal issues differently. And so there's a lot more room for argument about what the law is and what the law should be as applied to a certain set of facts. Also, trial courts, it should go without saying, have much more limited resources and time than the appellate courts. When you're at the Court of Appeal, you are presenting a brief and argument if at the district court level to a 3-judge or justice panel, and at the California Supreme Court, 7 justices. And so each one of them have chambers attorneys who are combing through briefs, reading everything in the record that a trial court probably did not have time to do. They're not only looking at the authority that the parties think is important, but they are conducting their own independent research. It's very, very common to see much more developed authorities coming out in opinions, and appellate courts even identifying issues that the parties didn't brief. Sometimes there's requests for supplemental briefing if an appellate court thinks something is important and is going to determine a decision. At the trial court level, I think the page limit maybe on a summary judgment is 25 pages. An appellate brief, include all 3 of them, the opening, responding, and reply, have 14,000 words. So you're looking at 70, 80 pages of opportunity to present argument to the court. So you just have, those features make appellate work much more different. There's an ability to talk about secondary sources. How's the federal court address this issue? How's the courts in other jurisdictions address this issue? And you just really don't see sort of that level of development at the trial court. And I love this decision I'm going to read, I apologize for a minute. It's called In Re Marriage of Shaban, and it was a 2001 case that was talking about whether an appellate lawyer should recover their attorney fees as part of prevailing party attorney fees. And the court said, appellate practice is in fact a specialty in its own right. It requires a different set of skills than trial practice. Appellate specialists are trained to frame issues precisely, develop persuasive legal narratives, and engage with the court on a higher level of abstraction than typically occurs in the trial setting. The appellate practitioner who takes trial level points and authorities and without reconsideration or additional research merely shovels them into an appellate brief is producing a substandard product. Rather than being a rehash of trial level points and authorities, the appellate brief offers counsel probably the best opportunity to craft original, professional, and on occasion literary value. So, and enough about promoting appellate specialists. Like I said, trial lawyers are excellent too, but it is a very niche practice. So for you all, the key, I think, in terms of preserving the record and identifying issues is just start thinking about them early, because what happens in the trial court defines what we can bring up in an appeal. And so it's very important just to really always be thinking about, is the record clear on this issue? Is the evidence I need in on this issue? And it's also important that things are being objected to, because waivers is very, very common on appeal. And you see waiver arise, obviously, if evidence is being offered that isn't objected to, if jury instructions are being submitted that are not objected to, special verdict forms, same thing. And, having done a couple trials myself, it seems like those oftentimes, unless you're in the federal court where you present them quite early, um, are last minute heat of trial. You're like in a 4 o'clock conference after having been in trial all day. And these are like very, very, very important documents in terms of what impacts a decision that's going to be forthcoming. So really take the time. I often get involved in some of those, submissions just because they are so important to a case. And sort of the flip side also is, if you're submitting a jury instruction and it's incorrect, you're going to face an invited error argument on appeal and maybe not be able to prevail. So examples of when to be thinking about appeals, even as early as if you're filing a complaint. I've been asked to review complaints with an eye towards not triggering California's anti-SLAPP statute, which allows briefing attorney fees and a direct appeal if a complaint raises issues challenging protected speech. So many plaintiffs do not want to go down that route, which is expensive, and it can be really a huge delay in getting to the merits of your case. Um, does a complaint allege facts supporting all the elements? Do attachments sort of defeat some of the things you're trying to say in your complaint? Just issues like that we see a lot up on appeal. Obviously dispositive motions, demurs granted without leave to amend, motions for summary judgment, those go up on appeal all of the time. And like on a summary judgment motion, I think it's very common, and this is great. You have some associates perhaps who are getting the declarations and the evidence together. But it's really critically important to read those declarations as if that person is testifying on a stand in trial. And has the foundation been laid? Are the statements in the declaration hearsay? So many times, and really this doesn't get fleshed out at the trial court, but it often gets fleshed out on appeal and people have more time. It may be a winning summary judgment motion, but the T's haven't been crossed and the I's haven't been dotted. And so it's very important, if you're going to bring a motion that's going to be dispositive, make sure it's airtight, because there's nothing worse than having a winning issue go up and then come back down for more trial court proceedings. I think I already mentioned, pretrial submissions, those are really critical in terms of locking those down to try and avoid later appellate issues. In bench trials, the statement of decision is really, really important. If you're the losing party, um, I think a lot of trial lawyers, the knee jerk is to always ask for a statement of decision. And I think maybe there's some lack of understanding of what the statement of decision is used for on appeal. It's used to punch holes into the trial court's order. So if I'm the winning party in a bench trial, I wouldn't request a statement of decision because all the presumptions on appeal are going to go in your favor, and there's no written document to sort of say, no, that's not what the trial judge was thinking or believed or ruled. And so the statement of decision, I get asked to get involved with all the time, or objections. And it's a weird, the rules of court on it are a bit tricky. So that's this important area to really be thinking about preserving issues or protecting a decision. Post-trial motions, obviously, there's judgments notwithstanding the verdict, motion for new trial, sometimes motions to vacate. Motion in terms of waiver issues, the only one that's really important is if a decision of a jury comes in and the damages awarded are inadequate or excessive. A lot of times we see that punitive damages. A new trial motion is a prerequisite to preserve challenge later on appeal. So you've got to bring that motion. Um, and new trial motions are also really critical for another reason. That rule that the trial judge can serve as a 13th juror is incredibly powerful. And sometimes um, that motion is more important than anything we can later do in appeal. If you can shift that trial judge, which I know is uncommon, but really get the court to understand, listen, you sat through this trial, and that jury just went off the rails, and you need to fix this issue. The judge has the power to do that. And so a new trial motion is really a strong tool in the arsenal, hopefully even to avoid an appeal or to be on the responding side if the court grants it. One motion I hadn't done before, but I just recently had to do is, so I was asked to come in and after a statement of decision, actually the tentative statement of decision had been issued. And so I was helping prepare objections, and it was an interesting trial. It was like a 20-day trial, and bench trial, and the judge had been very, very adamant, probably said 5 or 6 times during the proceedings, look at the calendar. You see these red X's on the calendar, which was when he was going on vacation. This is when trial's ending. Like, we're done. So he could not have been more clear that the case was ending on this particular date. Notwithstanding, he let the plaintiff, who I was representing the defendant, reopen evidence on important dispositive, really licensure issue. It was a case involving a contractor, and on the last 30 minutes of trial, so that the defendant had no opportunity to bring in a rebuttal witness. And of course, as a trial lawyer, you have to be careful with a bench trial because you don't want to upset your trial judge, who's the one ruling on your case. So while my attorney had appropriately objected and said, we're going to be prejudiced by this. This is late. There wasn't other statements. It was not like an offer of proof or something like, a request to continue trial. I mean, I can't even imagine what have happened. I think the judge in that case would have lost his mind. Like, have you not been listening to me? So anyway, um, we decide to bring a motion to reopen trial once we see the statement of decision, which is a tough motion, but it's permissible. And part of the thought process was, let's show the trial judge why his tentative decision is completely wrong, based on we have judicially noticeable facts that really affirmatively show that stuff that came in that last 30 minutes was just absolutely incorrect. Um, And even though, if you go up and if the trial court denies the motion to reopen, it's abuse of discretion standard, which is difficult, but the court will have before it, it'll see that evidence and that prejudice. If we hadn't done that, I don't, there's sort of a saying in the appellate world, if it's not in the record, it doesn't exist, it didn't happen. And so that is a post-trial motion that is new to me, but I actually think was pretty effective. So we'll see how, anyway, that works out. Um, and then in terms of thinking about appellate issues, I just note in high stakes litigation, on occasion, you know, it's not uncommon to have an appellate lawyer sit through trial or go down to important proceedings like the jury instruction conference, the verdict, when you're preparing what the verdict is going to be. If I didn't say so before, verdicts are just, I've had many, many appeals involving ambiguous jury verdicts, and there's just certain things that seem to happen repeatedly that open up that issue that could be avoided. For example, in cases involving multi causes of action, you could have causes of action that would result in duplicative damages. You're awarding damages twice. So a jury verdict really should have a way for the jury to calculate that, or to show, hey, listen, I'm finding liability on tort, I'm finding liability on contract, but I'm writing zero under the contract different claims because I've already given the damages under tort. And the reason that's so important, I had a case once that the jury did just that. It found all the tort claims. It wrote zero for all the contract claims, but what it really meant is I'm just not awarding duplicative damages, which is a standard, CASI jury instruction in a multi-cause of action case. Why did it matter? Because under the contract, we wanted to be the prevailing party for $1 million in attorney fees. And that was a crazy issue that could have been avoided if the verdict, we could have had the jury just write, liable, 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 and at the end total out damages. So anyway, that's another important area sort of to be keeping an eye on what's being submitted to the court. Um, so role of in-house counsel, identify potential appellate issues. And I mean, ensure, obviously, as you do with everything, that they're aligned with the company's business goals. I think that the cost benefit analysis is hugely important when you're talking about an appeal. From a sort of a media public perspective, you could have a published opinion, and particularly in Ninth Circuit, it seems like a lot of those cases get. It's not uncommon to have reporters at oral argument or contacting, me regarding a case, um, and it's important to understand, based on the issue, the identification of the issue, the standard of review that's going to be applied on appeal. What are my chances of success? How much is this going to cost me? I for example, you're deciding at the trial court, what's my motion strategy? And sometimes it seems like people just check these boxes and let's do a demur, then let's do a summary judgment if that's not successful. I had a case where someone brought a demur, sustained with leave to amend. Did it again, there was like 4 rounds of demurs. It was crazy. It was an 8 cause of action complaint. So finally, I think the clerk deciding the motion just was threw up his hands like, okay, sustained with leave. So of course the other side appeals, big dollar case. And, I'm up on appeal on 8 factual causes of action on demur. Hundreds of thousands have been spent on already at the trial court, and then you're defending that on appeal. And what is the standard for an appellate court looking at a demur? It's not just reading what the parties have submitted. The appellate court is tasked with reading the complaint and considering for itself whether it could come up with a cause of action out of these facts. So I've been at oral argument and had a justice say, well, couldn't a claim for this be stated based on those facts, even though the opposing counsel never came up with it? and the case will get sent back and reversed based on that. And so if my opponent is not opposing counsel, it's the whole three-judge panel. And so for me, maybe my bias is coming through here. I'm not a huge fan of the demur unless like you really have a clean, clear, like statute of limitations, res judicata, something like a defense like that, then go for it. Save money, do the demur. Otherwise, my experience is that demurs increase expenses quite a bit for companies, and there's a very high reversal rate, and you're right back where you started. You know, minimally consider whether it just makes sense to, I know you have to go through discovery, but whether it makes sense to just do that summary judgment motion. Um, and even on summary judgment motions, I think I pulled a reversal rate. They occur in about 29 to 35% of cases. And the reason for that is an appellate court um, owes no deference, obviously. If it's just a decision of law that a trial judge has made, an appellate court is equally well suited to make that same decision. And so, you know, they have no problem reversing summary judgments, and sort of, you know, they're looking at it with an eye towards someone's been denied their day in court. And so we do see a lot of reversals with summary judgments. I did want to mention also, and it's important to know certain issues can only be challenged before judgment, and that's by a petition for writ of mandate. A writ is basically an emergency appeal. They don't have high chances of success because they interrupt the court's calendar. But there are certain writs that can only be brought before judgment, and there's statutory timelines for them. So I wanted to tick off a couple of what those were. So if you file a peremptory challenge of judge and that doesn't get granted, the writ is the only way to challenge that. You can't challenge it later after a judgment and say, hey, this guy was biased or this gal was biased. Same deal with when you bring motions challenging opposing counsel for having a conflict of interest. That is a denial of that motion's challengeable only by way of writ. An order denying a motion to quash for lack of personal jurisdiction. And in the anti-SLAPP context, which I mentioned before, if some but not all causes of action get knocked out, that would be also a writ challenge. And an order refusing to disclose public records under the Public Records Act also would have to be challenged by writ. Last thing, and there may be others, this is not a totally inclusive list, but orders granting or denying good faith motions, there's actually a district split. But some courts say you have to bring a writ to preserve challenge of that order. So the decision whether to appeal is obviously an important one. You know, there's reputational issues, as I mentioned, if the opinion's published, you know, you don't want some decision out there that's really slamming your client, your company. You know, operationally, it distracts from the business at hand. There's, you know, financial consequences. I had an appeal where I was pretty, you know, candid in looking at the issues and telling the client, which was publicly traded, you know, it's probably a 10% chance of success. The standard of review is really, really challenging. But the business people said, listen, we think the trial judge got it wrong. We understand what you're saying. You know, we want to go forward. And I also emphasized, you know, this is a contract case. You have a 1717 prevailing party attorney fee clause. Please understand, not only are you liable for the fees at the trial court, which have already been awarded, but if we lose, you're paying my fees, and you're going to pay the fees of the opposing appellate counsel. And so, you know, they decided to go forward, and they lost. And you know, there's internal reasons for doing things like that, which I 100% understand. But I think it's just so important to be fully informed of what are the ramifications of going down this path. And then last point on that is, and I've done it, but I really don't think it's helpful, is people think filing an appeal is leverage for settlement. that has not been my experience. I think in 30 plus years, I've had maybe less than 5 cases settle on appeal. And that's even given, like, for example, down here in San Diego, the fourth district has a free mediation program that you can have an appellate justice sit on your case. Um, and try and settle it to avoid having to go through the appellate proceedings. And I've offered that out to opposing counsel, and it just seems like people get very solidified in their positions, and it's very tough to settle a case on appeal, and particularly if the other side has been deemed the prevailing party for attorney fees. What do they have to lose? You know, they're probably thinking, well, we'll get all of our attorney fees for the appeal too. So not a lot of motivation in terms of reaching a settlement on appeal. It's not impossible, but that would not be a driving reason for me to file a notice of appeal. So, timelines. And this is mainly in the California state courts. And the timeline for filing a notice of appeal is tricky. Let me just say that. It runs from notice of entry of judgment, and that's a term of art. And what that means is if the judgment or the appealable order is served with the proof of service to the counsel, either by the clerk or by opposing counsel, your time for appeal is ticking. Um, there is no requirement, as some people think, for a document that actually says notice of ruling or notice of entry of judgment. It's that proof of service with the file stamp judgment that triggers. The rule is generally 60 days. If post-trial motions are filed, it extends to the time is 30 days beyond an order deciding those motions. The caveat on that is it only extends the time to appeal if the motions were valid. And California common law has interpreted that to mean those post-trial motions must be timely. So if someone messes up on a post-trial motion timeline and you're running your appeal date from that, you're going to be jurisdictionally barred. And then last, if no one serves the judgment and if there's no post-trial motions, then the outside deadline to bring an appeal and the judgment is sitting in the file is 180 days from when it was placed in the file. So from that, I did want to mention one issue. Um, there is a question about, I said it must be served judgment, file stamp judgment with proof. I have a case right now where someone slipped a file stamp judgment in as an exhibit to a cost bill, but did not separately identify the judgment um, on the proof of service. And this is, I wasn't involved at this point. So then I get the case and the judge denies post-trial motions as untimely because supposedly having it as an exhibit triggered. Fortunately, it didn't impact the appellate timeline because we filed early. But so that one is up on appeal right now. And I think it's an interesting issue. I think actually it's going to be reversed because I can't imagine a court of appeal is going to allow that kind of gamesmanship. I mean, it needs to be really clear when your deadlines are triggered. And that's why it's the proof of service, it's a file stamp judgment, and that document is identified in the proof. Anyway, I digress. I digress. I think that's an interesting case, though. So look out for that one. So once the notice of appeal is filed, you have 10 days to designate the record. And what that means is you're telling the Superior Court how to get everything to the appellate court who has nothing. And there's a couple considerations here that I wanted to mention that are important. So your counsel can file the opening brief and prepare an appendix with their own documents. Um, and or you can ask the clerk of the court, you just list what documents you want, and the Superior Court clerk prepares what's called a clerk's transcript. Why is that important? Well, if you're looking to delay, like you don't want a quick decision, ask for a clerk's transcript because the Superior Court tends to take a really long time to get those done. Same thing with you have to designate reporters' transcripts that you want. If my clients are looking to save costs and to move the appeal ahead quickly, I will, if we have certified copies, I'll file those myself, number them and file them just like a reporter would do on appeal. And it gets everything going much more quickly. If you want a delay, well, then ask the reporter to do it because they tend to take a long time and ask for a lot of extensions. So that's sort of record designation. There's some cost considerations there. Um, Typically, it's less to have your own counsel do it, but not always. So I would say the main consideration there is timing. So once the record designations are done, the case typically sits dormant for a while. Um, and you'll get what's called a notice of filing of record from the Superior Court, and that triggers a 40-day deadline to get an opening brief on file. After that, there's 30 days to get the response on file, 20 days for reply. And each of those briefs, I would say extremely, extremely common, get extended by at least 60 days. The California rules of court allow counsel to stipulate to 60-day extensions on each of those without the requirement for a court order. You just file the stipulation, it's automatic. And if not, you can file applications for extensions. And um, a lot of times clients don't want to extend. And what I tell them is the time for the resolution of the case typically runs from when the notice of appeal is filed as opposed to briefing. Um, and so it makes no difference in terms of how quickly your case is going to get resolved. And appellate courts like appellate counsel to get along. It's a much more civilized court. They see lots of the nastiness in the writings from the courts below. And so if someone were to ask me for a 30-day extension and my client said don't, I would highly recommend that we just remain silent and let them have to file an application and just say she didn't respond. It's really not looked on um, very favorably by the court to just say no, unless of course there's a good reason. Sometimes, I have an older client or I have a judgment that's incurring a lot of interest and I explain, we really need to get this appeal moving. Unfortunately, I can't stipulate. So that's extensions. Once briefs are filed, again, case sits dormant probably, and I'm talking mainly fourth district, second district. Um, Actually, all the courts of appeal are around these timelines. Um, so the case will sit dormant for 3 or 4 months until we get the notice of oral argument. And just so you know why briefs are so important, what's happening during that 3 and 4 months is that each chambers for the three panel members who we don't know who they are, reading the briefs, preparing bench memos. Down here in Division One in San Diego, one particular chambers takes the lead, and they circulate that memo to everybody. And so when you go in for oral argument, they're very up to speed on the record, the legal issues, and have a pretty good idea of what way they want to go. Um, it's a little different than the Ninth Circuit. I would say my experience is that the panel members have not conferred as much. I don't believe that there's a single bench memo that's circulated or a lead bench memo. I think everybody comes with their own bench memos in the Ninth Circuit. So you can feel it in argument because it isn't quite as unified as oftentimes when you show up for argument in the fourth district or the second district in LA. It seems like everyone's looking at the same paper and sort of exploring the same issues and concepts and leaning a certain way. So in my view, the brief is the most critical part of an appeal. It's very uncommon, I think justices will tell you, to have oral argument flip the outcome. It may change nuances about that decision or the opinion that's going to issue, but very uncommon for it to flip. So once you've had argument and there's no tentative decision given to the lawyers beforehand, except for there's one division in LA that does give tentatives. Oh, actually, I take that back. And Riverside gives tentatives. Um, the court has 90 days in which to issue its decision. The federal court has no limit on timeline. I'm waiting for a case right now. It seems like forever. Um, so the result is from notice of appeal to decision, you're probably like a year and 3 months, a year and a half. I've never seen an appeal resolve in quicker than a year. Um, and the federal court is probably along those lines. As I have noted here, the time for appeal in federal court is 30 days, not 60 days. That's important to know. Oh, I did not mention, but I'll move to the next slide to talk about this. Bond requirements. This is a big thing that comes up a lot. Um, so even though you have these deadlines for an appeal, 10 days after a judgment is issued, the other party can start executing. So the only way to stay execution of a judgment is to file security. And typically that's an appeal bond, although sometimes people do cash deposits in lieu of bonds. But so bonding is super important. It's important to be prepared for that because it comes up really quickly. And people start trying to get at bank accounts and setting, debtor exams. You want to make sure you do that. So a lot of times, even though I have 60 days to get a notice of appeal on file, um, I we've got to get that bond set up. And there's companies that are really specialized in it. I just wanted to touch on it. I'm not an expert in this field. But typically you're looking at a surety bond that involves a premium of 1 to 2% a year. The amount of a surety bond on a money judgment is 1.5 times that judgment, including costs and attorney fees. So, I mean, I had like a $40 million judgment. We had a bond, and that was crazy. Um, and same thing with the cash deposit. You can file, if you don't want to pay that bonding premium, I've had clients file checks at the Superior Court. The problem is you're not collecting any interest whatsoever on that. And so there's some investment financial considerations there in terms of bonding a judgment. And in some cases, if you're dealing with two solvent companies, the money's going to be there if you pay it. It is an option to pay a judgment. You want to take steps to ensure you're not waiving your rights on appeal. And that way you cut off that post-judgment interest and you're not dealing with all of those bonding issues. I've had Superior Courts lose the original bond, and they seem to delay when we deposit money in the court and win and say, hey, we want our money back. And you call the clerk and they're like, yeah, we'll get to it when we get to it. My client's like, we'd like our money back. So just highlighting a couple issues with bonding, which is a big part because stays are a huge part of being able to proceed with an appeal. Let me get to some statistics for you all. So these are from 2023, 2024. Civil appeals were affirmed in 80% of the cases, so 16% reversed and 5% dismissed. About 8% of the opinions were published. And I'm finding courts, unless it's really a novel issue, don't publish out of the gate. But if you file a letter and ask them to publish as a party, or even I've had a third party on one of my appeals file and say, listen, this is important to an industry. We would appreciate you publishing this. It hasn't been just addressed before. That can happen. And then I have the statistics for the processing time, which I've sort of hinted to before. So in terms of analyzing this, so standards of review could be a whole another hour discussion. So I just wanted to lightly touch on them because they are the most critical point in terms of analyzing, is it worth it to bring this appeal? So de novo review, that's legal rulings. That's your best standard on appeal. The appellate justices have zero obligation to consider what the trial court said. And so for that reason, that's why I gave you the summary judgment reversal rate is they don't agree with the analysis of the law by the trial court. Reversal, you go back. Abuse of discretion, another standard, that's a pretty difficult standard on appeal. And it looks at whether or not the trial judge acted in the bounds of reason. So depending on what the issue is, the court looks at, okay, here's the statute that talks about admissibility. Um, and these are the facts the court found as to, like weighing whether or not something should come in. Do we find that's within the bounds of reason? Most often they do. Even if they, as a trial judge, say to themselves, well, I wouldn't have ruled that way. Under the abuse of discretion standard, it's much more difficult. And then last, substantial evidence standard, that's jury verdicts, that's factual determinations. That's a really tough standard on appeal. And that's a really expensive appeal, let me tell you. And here's why. I had a case, it was for a commercial landlords, probably a 4-week bench trial. And there were a lot of, actually, I took the case, there were a lot of great legal issues involving the commercial lease and whether or not this tenant was allowed to terminate the lease, which they had done. They claimed that there was some kind of a contaminant in their suite that permitted them to rescind the lease midterm, and they didn't follow any of the lease provisions in terms of, giving notice, anything like that. Um, and so goes to trial. There's all kinds of evidence on, um, there's no question something was in that suite. Like there was something. And there's no question that it was causing some medical issues for the tenants. But the plaintiff had failed to offer an expert who actually came in and said, this tying it to something in the suite. What they were thinking was air conditioning, whatever. And so our position on appeal was, even though it was interesting, the whole case had been litigated over these litigation commercial lease provisions. We came in with authorities that talked about, like medical issues and asbestos and having to prove causation, and said, listen, that just didn't happen here. And so the jury's verdict is not supported by substantial evidence. And the Court of Appeal actually agreed. So that's an example of a tough standard, but what you have to do is that appeal, I had to outline, you can't ignore the other side's evidence. You have to talk about everything that was presented and explain why it wasn't enough. And there was authority in California that said you have to have an expert. It's not enough to have witnesses come in and talk about causation when there's a medical issue involved. So, and as I noted, the standard of review is often what determines success. So, getting close to wrapping up here, strategic issue selection. That's a really important. It's a really important topic because I think it's so common, um, to want to put 5, 6, 7, challenge everything in a brief. And really, you should be looking at your top 2, maybe 3 strongest issues. They need to be prioritized. They need to be clean. If a kitchen sink approach is taken, it just signals to the appellate court you have a weak case, and it weakens the issues you might have a chance on. And so sometimes it's tough to let those issues go, but it's really important. So not to dilute. Also thinking about, broader legal impact to your industry, to your client, and making sure, that potential outcomes on appeal, potential outcomes that could be stated in a published opinion align, with your company's long-term goals. And last, key takeaways. So, hopefully I haven't spoken too quickly and given you too much information, but I think start thinking about appeals early and whether it makes sense to collaborate with an appellate lawyer. Appellate lawyer doesn't have to come in and take over a whole case. Like I get calls daily to, what do you think about this? I just got a bad tentative. How am I going to protect the record on this? Like those are sort of areas where it might be useful to have a conversation. And if I didn't say so, please have a reporter's transcript for trial, but for the key trial court proceedings, reporter's transcripts for appellate lawyers are critical. and preserve the record carefully. That's part of it, that reporter's transcript, but also, objections, file motions in limine on those really, key issues, start signaling those to the trial court. And so then when you go up on appeal, you can say, hey, this was no surprise. This didn't come out of left field. Like, we flagged this multiple times. Make sure trial lawyers are asking for standing objections or making offers of proof when needed. Know your deadlines. I talked a little bit about that. And then choosing issues, as I said, standard of review, making sure they align with your company's long-term litigation and policy goals. So with that, Audrey, I'm not a techie person. I'm not sure I can see the chats. If anyone has any questions about something I've talked about or anything I didn't talk about, I'm happy to answer any questions. So I did open the chats. I'm not seeing any questions. So I would just thank everybody so much for your attention and your attendance, and I hope you have a great afternoon. Thanks.